Basic Appraisal Principles, page 216, Unit 3, Legal Considerations. Number 4, if there is no surviving spouse and no surviving descendants, such as children, grandchildren, etc., everything goes to the deceased person's parents. Number 5, if there is no surviving spouse, descendant, or parent, the estate is divided among the descendants of the deceased person's parents. In other words, among the deceased person's brothers and sisters or nephews and nieces. Number 6, if there is no surviving spouse, descendant, parent, or descendant of a parent, the estate goes to the deceased person's grandparents or descendants of the grandparents. Number 7, if there is no surviving spouse, descendant, parent, descendant of a parent, grandparent, or descendant of a grandparent, the estate goes to the next of kin. And lastly, number 8, if there are no surviving heirs whatsoever, the property will escheat to the state. Escheat is explained in Unit 2. In addition to states having their own rules and regulations in regard to wills, probate, and intestate succession, they may also have specific rules and regulations pertaining to spousal rights after death. When completing an appraisal assignment that might have these topics in question, refer to the state's statutes for clarity. Other ways of acquiring rights. When we think of acquiring rights in property, we ordinarily think of the property being transferred voluntarily by deed or will. However, there are other ways of acquiring rights in property that are less common, but just as effective. Rights in property may be acquired involuntarily through adverse possession or by the creation of a prescriptive easement or an easement by necessity. Adverse possession. Adverse possession is the process by which possession and use of property can mature into title. The idea behind adverse possession statutes is to encourage the fullest and most productive use of property. Each state has its own set of requirements that must be met to establish title by adverse possession. Easement by prescription / prescriptive easement. Another way that someone may acquire rights in property is by claiming an easement by prescription, also known as a prescriptive easement. Prescription is similar to adverse possession, but it merely leads to an easement, not to a transfer of title. An easement by prescription is established by using the property as if an easement already existed. As with adverse possession, each state has its own set of requirements that must be met to establish an easement by prescription. Easement by necessity. An easement may also be created by necessity. If an easement is essential to the use and enjoyment of a parcel of property, a court may rule that there is an easement by necessity. For example, if the landlocked property had been purchased from an adjoining property owner, a court may rule that there is an easement by necessity. Page 217, Property Transfer Disclosures. Now that you have an overview of various ways in which ownership of real estate can be transferred, let's return to the most common type of transfer: conveyance from a seller to a buyer. The desire to sell the property quickly and for the highest possible price might tempt a seller to conceal problems with the property from potential buyers, or at least to avoid mentioning the problems. That tactic is likely to backfire, however, and the seller may end up involved in an expensive lawsuit. To avoid liability, a seller should disclose any material information that might adversely affect the use or enjoyment of the property. There are also specific statutory disclosure requirements that a seller must comply with in certain circumstances. Property disclosure statements. In a residential transaction, most states require the seller to give potential buyers a detailed property disclosure statement form like the sample disclosure shown in Figure 9.2. This type of form is intended to be filled out by the seller, not the real estate agent. The seller should answer all questions to the best of his or her knowledge and sign the form. The form expressly states that the disclosures are not to be treated as warranties or guarantees concerning the condition of the property. If the condition of the property changes, the seller should revise the disclosure accordingly. State-specific property disclosure requirements. Each state may have its own seller's property disclosure requirements that appear in the form of an addendum to the purchase agreement. These vary extensively from state to state and can range from only a few questions to over 100 questions. Some states allow owners to pay a fine to a buyer if they do not fill out the disclosure. Typical disclosures include material facts about the property, including known problems and/or repairs, whether the property is in a floodplain, if the property is subject to any known easements, any known environmental issues, and so on. Even before most states enacted seller property disclosure requirements, they had fraud laws on the books. Fraud is generally defined with respect to real estate as either lying about or failing to disclose a known fact or condition which would have influenced the buyer's decision to purchase the property. Therefore, if a buyer had failed to ask about any easements, for example, and the seller, knowing there was an easement, had remained silent about it, the seller would generally be guilty of fraud. Federal lead-based paint disclosure. In transactions involving housing built before 1978, construction permits prior to January 1st, 1978, federal law requires a seller to disclose information concerning lead-based paint to potential buyers. A landlord is also required to make these disclosures to potential tenants. About 3/4 of the homes built before 1978 contained some lead-based paint. The paint is usually not dangerous if properly maintained, but if it deteriorates, it may cause brain damage and organ damage in young children. Extra notes. What does that say? Sold his land in Taos for $5,000 a piece. 5-acre tracts. How do you get here? What? Something without kids. Oh, I think she was telling me a story about how this guy he got in trouble because he was selling plots of his land, and he was selling some that you couldn't get to without having to cross over the other plots, which was illegal. Similar to adverse, I think that's what it's talking about in easement by prescription, kind of similar to adverse possession. With adverse possession, no, you can acquire title just by sitting on the land and paying the taxes and improving the land a bit. And if no owner gets you off the land, I think it's in a certain amount of years, you can take title. Landlocked property, and that's what it was talking about. You have to have access for everybody on their pieces of land. You can't landlock them out. Under the Constitution, you have the right to ingress and egress. The court can force easement. Just an example I think we were doing in class. It shows Leo, John, Mike, and Seal, and then it shows like a dotted line. I think that's what we're talking about, that there needs to be an easement for Leo's land so that it's going over this land and that one. No such thing as landlocked because you have to have access to your property. Put that down in the addendum.